Where to start a Spanish inheritance process? People who have lost a loved one unfortunately often are faced with a lot of practical issues, both for the funeral and the later inheritance process. If this person wasn't of Spanish nationality, but was resident in Spain or had assets here, it's even difficult to know where to start with all the paperwork. C&D Solicitors in Malaga can help you with carrying out the complete Spanish inheritance process. We can do so on a full-service basis, and in our office we speak several languages. This way, you don't have to worry about the practical side of your loss. To be able to inscribe the deceased's properties, like a house, bank account or car, in name of the legal heirs, it is always necessary to sign the inheritance deeds at the Spanish notary. Mostly this is done by a lawyer that represents the heirs through an official power of attorney. He will provide the notary both with the death certificate as with an extract of the central registry stating if there was a Spanish last will, and if yes, where it was signed. In this case, the notary of course also needs to receive a certified copy of this last will. An essential question to determine in the inheritance deeds is which inheritance law applies, the Spanish or the foreign law of the deceased's own country. In this overview, you see that this matter is rather complex, but it's very important as the Spanish law is inflexible. When it applies, the biggest part of the properties always is inherited by the children or other family members. This means that if you are a married couple resident in Spain and you want the longest living to inherit your belongings, you always need to sign a last will, appointing your national law and your spouse as legal heir. If the foreign law is in force, additionally either a probate document or a declaration of the law will be required by the notary, which states who the legal heirs are according to the foreign law. In Andalusia, heirs that are close family members like spouses, children, grandchildren or parents usually don't pay inheritance tax, but the declaration still needs to be done. Therefore, once the inheritance deeds are signed, the lawyer will fill out the obliged forms and pay any taxes for heirs with another relation status. Depending on the official residency of the deceased, he will send the documentation to either the regional or national tax office. Next to that, the lawyer will make sure that the local plus value tax is paid, if applicable. When the inheritance deeds are returned with the right stamps, the lawyer can then take care of the correct inscription of any real estate in the name of the new owner at the land registry and cadaster. This document will also serve to change the title holders of a bank account or a car. The whole process from the signing of the deeds at the notary until the end of the project takes about 3 months. When the legal work finally is completed, we of course provide our clients with all bills, proof of payments, original documentation and the final balance of the total project. However, as you can imagine, not all inheritance processes are completely the same, and sometimes it's necessary to take extra steps. In some cases, for example, if the deceased wasn't a close relative, it's possible that our lawyers will conduct a pre-search in the different registries to find out if the person had any unknown assets in his or her name. It's even possible that they take care of the sale of an inherited house if the new owners don't wish to keep it. In this scenario, the client will receive the mentioned final balance, after which will transfer the proportional net amount of the inheritance to the bank account of the legal heirs. Would you maybe like some more information about last wills, inheritance tax, or do you wish to receive an offer for the legal work of your inheritance process? Please don't hesitate to contact us. We speak English, Dutch, Swedish and German, and we'll be happy to assist you in these difficult times.